The Supreme Court today granted a partial stay on certain provisions of the Waqf Amendment Act 2025. While the court refused to halt the entire law, it stepped in to protect rights during the hearings. Here's a breakdown of what changes on the ground. The bench led by Chief Justice B.R. Gavai observed that an act passed by Parliament enjoys a presumption of constitutionality and can be stayed only in the rarest of rare cases. But to balance interests, the court has paused key provisions. The law required a person to be a practicing Muslim for at least 5 years before donating property as a waqf. The court did not find this arbitrary, but stayed its enforcement until the centre frames clear rules on how such practice will be determined. Provisions giving district collectors authority to decide disputes over waqf property have been stayed. The court said only tribunals and courts can decide ownership, not the administration. Until then, waqf properties cannot be dispossessed, records cannot be altered, and no third-party rights can be created. The government had abolished the age-old concept of waqf by long public use. The court refused to interfere, noting that waqf registration has been required since 1923. It ruled that unregistered waqfs for over a century cannot claim protection now. The court limited participation. The Central Waqf Council can have no more than 4 non-Muslims out of 22 members, and waqf boards can have not more than 3 non-Muslims out of 11. The law permits any official, but the court directed that, as far as possible, the CEO should be appointed from the Muslim community. Meanwhile, provisions excluding ASI monuments and tribal lands from waqf remain untouched by the court. So what does this mean? The Waqf Amendment Act 2025 remains in force, but with important safeguards ordered by the Supreme Court. The final word on the controversial law will come only after the petitions are fully heard. This is Apurva Adhikari for NDTV.